like your questions, keep the applause to the finish. Look, I do have another name too, by the way. Macca's just the nickname. But most of you have been listening to me for a long time, so I thank you for all coming along and listening again. And it was always good to go second because more people come into the room. You know, Timmy had the daunting thought of just appearing before about 50, but I've got about 150, so I'm quite pumped up about that. So thanks for coming along. I'm going to talk about things that I always talk about, actually, and the reason I talk about the same things all the time, I figure that if I just keep doing it time and time again, eventually you'll all become experts at industrial relations, and given that labour costs represent at least 50% of the way we operate our businesses, it's pretty important that we understand what labour laws are all about. One of the things that happens for me anyway, is that I get to represent a lot of you through APTIA because unfortunately, even though you come along to my talks from time to time, you fall asleep and don't listen, and when you don't listen, eventually when you're not doing the right thing, eventually a driver goes to the union or goes to the Fair Work Ombudsman or goes to their lawyer, and then unfortunately you come to me when you're up the creek without a paddle, and my role is to find the paddle. Which we invariably do. So just in a broad sense, I haven't even checked to see whether I can work this yet. Yes, I can. In a broad sense, before I get onto the general topic, I want to just broaden it out for you so you understand what industrial law is. Industrial law obviously is that law that impacts between you as an employer and your employees, or in the case of a number of you who are employees, in relation to your rights as employees. And in our country, it's underpinned by an act called the Fair Work Act, which you've all heard about, and it's then underpinned by a set of safety net measures. One of those safety net measures are the things called the National Employment Standards, and they apply to everybody, irrespective of the amounts of money that you earn. Alongside of the National Employment Standards are awards. They are limited to about $133,000 income these days. It does get indexed each year, but generally there is an award for most employees, and you've heard me say this before, people like Pete and Timmy don't have awards because A, they get paid too much, and secondly, lawyers just don't have awards, you know. And then behind the awards and the National Employment Standards are enterprise agreements, which some of you negotiate with your workforce. And, you know, I have a lot of talks with you in relation to enterprise agreements, and even some of the smaller operators want enterprise agreements because they work on the basis that if they've got a document in place, whenever any new employee comes to work with you, that new employee understands entirely what basis their terms and conditions will be. In many cases where operators don't understand the nature of the laws, they just pay what they can afford. Unfortunately, that's not good enough because when a claim comes in, they can't afford the claim either. On top of that, you have work health and safety, which is something that you've always got to be mindful of. And in New South Wales this year there's been 3 significant bus crashes which resulted in 2 deaths, and you know, we have heard from the past some of the problems with deaths in the workplace. And then we have new bullying and harassment laws which are based on work health and safety principles, but they now apply under the Fair Work Act. There are new rules in relation to consulting with your workforce, and of course at the end of the day you've got to pay correctly, and this is where state associations are important because they outline the correct pay rates, the recommended pay rates, and how you should you know, meet those payments. So I always say to you, contact your state association to find out what the correct amount is that you should be paying, because if you don't, unfortunately, and claims are made, then you get into all sorts of strife. So I just want to talk a little bit about now some of the minutiae. I've only got 10 minutes, so it's not going to be too bad a medicine for you. Just in relation to the award itself, the award underpins everything. So the way in which you pay your employees are underpinned by the awards. Even the enterprise agreements that you have at some stage of the piece are impacted by the way you pay your workforce. In Victoria and in New South Wales, traditionally bus operators have always been paid a lot more. In Tassie and South Australia particularly, they have a complete requirement for the award. In Queensland, particularly the smaller school bus operators, as you get further away from the major centres, the PVTA, the Passenger Vehicle Transportation Award, is the most critical document that applies. So any changes to the PVTA will impact on you. What Vic did many years ago, and what the operators and state associations did many years ago, they formed APTIA as a national body, and my role is the protector of the PVTA. I watch the door to make sure that nothing slips in the door that's going to impact dramatically on your businesses and cause you some grief. Unfortunately, every couple of years they have a review of the Modern Awards. They had a 2-year review 2 years ago, and they are having a review of the Modern Awards now. And current common issues that are being considered, and Timmy just commented on it before. In our system, we never paid leave loading to employees for unpaid annual leave when they left. We didn't have to. It was an exclusion in Part C. It was an exclusion in the other awards, and when the PVTA came out, it was an exclusion. It remains an exclusion today. So, you know, if you have an employee and they leave you, you don't have to pay them the leave loading, except for the fact that the Fair Work Ombudsman reckons you have to, and except for the fact that it's a sort of given that it's a very ambiguous set of circumstances. And as Tim rightfully said, this current government has legislated, and there is a bill in the House that's actually on the agenda for this week and may get passed this week, that supports that exclusion that we have. There's 122 awards, and we're one of 16 awards that has that exclusion. So even though we're a little industry, we're important when it comes to leave loading on termination. That's what I keep telling myself anyway. But it will cost you a fair bit of money, because in New South Wales they pay a 25% leave loading, for instance. So you'd be paying a lot of money if you were forced to pay it. The ACTU, God love them, tried to remove that exemption. That exemption's currently before the Fair Work Commission, and our role is to try to oppose that. That's what we're doing, but we're also hoping that the bill goes through that puts that to bed. In Western Australia and the Northern Territories, there are district allowances. Those district allowances will terminate as at the 31st of December this year for the Western Australians and Northern Territorians. But again, and the Victorians have accident pay as well. That terminates at the 31st of December, except the ACTU has applied to extend that. They're the sorts of things that we're opposing. Other things that will come up in common issues are public holidays. For a long time, the ACTU has been trying to convince the Fair Work Commission that you should pay public holiday pay for a person who's not rostered. So at the moment in our industry, if you're not rostered on a public holiday, if that's not your usual rostered day, you don't have to pay any public holiday payments to them. The way the ACTU sees it, however, is that you should pay the holiday or the public holiday pay. Obviously, we're going to oppose that. There are some issues with casuals and part-time. The ACTU are consistently pushing this concept of casual conversion clauses, so that if you've been a casual for more than 6 months, they seek to have a mechanism which requires you as an employer to consider putting that person on as a permanent part-timer or a permanent employee. That's something that we've opposed because we want the flexibility. In our industry, we need to employ casuals. You know, we can't be being pressured every time that we have a casual who's been there for more than 6 months to actually go and become a permanent or a permanent part-time employee. So these are the types of common issues that are going to impact on the PVTA. At the moment, there are 2 applications by the ACTU to vary the PVTA, which we're opposing, that leave loading issue, and the extension of the accident pay and the district allowances. There are some other applications about cashing out annual leave and excessive leave, but we've deliberately not become a party to those. The PVTA itself is due for review from September. There hasn't been a return date or initial return date yet, but we're anticipating that the Transport Workers Union will seek to have some reviews of the PVTA, and one of the biggest impacting reviews will be this issue of school bus drivers. Excuse me. Currently under the PVTA, if you're a school bus driver, if you're driving a larger bus with more than 25 passengers, you only have to pay them grade 3 under the PVTA. If it's a small bus, grade 2. What the TWU have been arguing for a long time is that if you're a school bus driver and you actually collect fares or issue tickets, which some do in some states, then it should be grade 4. And that will impact dramatically in Tasmania and South Australia, for instance, where their whole funding models are designed around grade 3, and they're very tight funding models. The concept of having to pay grade 4 will push up the payments for your casuals, by a good 10%, for instance, which at the moment isn't calculated into your funding model. So that's going to be an issue that APTIA, as a national body, will seek to oppose. One of the other things that the TWU will be seeking is that they are seeking a 10-hour non-engagement period in between shifts. So if you've done a shift and you're working overtime, in other words, you're doing a night shift to the theatre or whatever, and you've got to start at 6 in the morning, there won't be a 10-hour gap between when you knock off and when you start. The TWU's application will require you to either not roster them on, or if you do roster them on, to pay time and a half or double time or a penalty for that period. So you're sort of getting the drift of the types of things that your national body has to keep an eye on, at the gate, to make sure these things don't slip under the gate and end up costing you a lot of money and causing your state associations grief by going to governments who are tight as, who don't want to give you the extra funding. So they're the sorts of things. This issue of the minimum engagements, the ACTU has flagged that they might try and extend some of the minimum engagements from 2 hours for school bus operators to 3 hours. So there are plenty of things for us to look at. In relation to the review, there will be a different PVTA, because the Fair Work Ombudsman and the Fair Work Commission have both flagged that they are going to try and make the modern awards even more simpler by giving examples of when casual loading should apply. And one of the things that I would suggest that you all do, and that is, if you do the payrolls yourself, then do it yourself. But if you have somebody do your payrolls, take time to actually go and talk to your payroll clerk or your payroll person and make sure they understand how to correctly pay the employees. I don't know how many operators I go around where they get an agreement, whether it's an enterprise agreement or the award, they give it to the payroll clerk and they go on and do the rest of their things in the hope that the payroll clerk actually knows what the award is about or what the enterprise agreement's about. And if they don't know it, then you'll find for years you've been paying the wrong amount, and sometimes you've been overpaying a lot of money, sometimes you've been underpaying a lot of money. Beg your pardon? 2 minutes? I can't get through it in 2 minutes. So just the other things that I wanted to talk to you a little bit about were things that happen with the National Employment Standards, these family-friendly arrangements where if you are a disabled person, if you're a carer, if you're 55 or older, if you're experiencing violence in the workplace or a carer, then you're entitled to go to your employee to have variances to your time and hours of work. Consultation is an important thing in our industry, which is causing a lot of concern. If the circumstances are now that if you're changing rosters or changing the hours of work for a person who's not a casual. In other words, it applies to a casual who systematically works for you, like a school bus operator. If you're changing their rosters or you're changing their hours, you have to sit down with them and actually talk to them, and you've got to put to them what's happening, and you've got to give them the opportunity to respond, and then you've got to make a decision. I have done a quote on what it means to consult, and I will read it because it is worth reading. The word consult means more than one party telling another party what it is that he or she is going to do. The word involves, at the very least, the giving of information by one party, the response to that information by the other party, and the consideration by the first party of that response. The right to be consulted is a substantive right. It's not to be treated hastily or as a mere formality. So I guess what I'm saying to you is it's not a case of, Charlie, we're changing the rosters, here they are. What do you think about them? They're already changed. It's, Charlie, I'm thinking of doing this. What do you think about it? Pete, you're an absolute assassin. Thank you for listening to me, and I look forward to speaking to all and any of you as you wish during the course of our business year. Thank you.
Sorry, Macca, we're at a tight schedule. Look, we've got time for a couple of questions. So, does anyone want any questions? I might ask one question. Macca, you didn't get to your conclusion, but in terms of essential industries, transport, do you feel that you're going to be successful in convincing the authorities that transport is an essential service?
Well, thanks, Pete. You cut me off, so at least you gave me a lead into that last slide. Yeah, I've taken the view, and our industrial working group's taken the view, that they'd like to lower the bar to strike action in public transport. All hell breaks loose if protected action ballots are created, and it's very difficult to stop it. We saw how it was stopped with the Qantas dispute a couple of years ago, where 20,000 people got stranded overseas. Well, getting stranded at a bus stop's just not enough to get the Fair Work Commission to stop it. So what APTIA will be looking to do in the Productivity Commission inquiry that's promised next year is to try to lower the bar. The APTIA national policy has always been that they're not afraid of arbitrating an enterprise agreement, so that the situation would occur that if you couldn't reach agreement with your employees and strike action did take place, after a period of time it would be reasonable to call upon the Fair Work Commission to actually arbitrate the enterprise agreement, so that matter could be resolved. You could then go to your government and say, righto, this is the arbitrated agreement, this is the basis upon which we're funding our agreement, and that's one of the bigger picture items that APTIA is looking at. Thanks, Pete.
Thanks, Macca. Okay, we've got to finish this session. I'm proud to say Piper Alderman sponsored this session. We're very proud to be part of the big conference, and as I said, this is the biggest that I've ever attended.